Are you a Queensland real estate agent? If so, my name's Josh. I have a law practice in Rockhampton, Fox Law, and I thought today I'd talk a little bit about just some considerations regarding COVID-19 and sales contracts in Queensland. I'm going to run through some frequently asked questions, but just by way of general comment initially, what we're seeing is that banks and others are experiencing some delays at the moment, whether that's just difficulty with social distancing or issues with building and pest and being able to get into the property. I tend to think pushing out the timeframes of the contracts at this point in time is a good idea. Often we see the 14 days for finance and building and pests and 28 days for settlement. And that certainly has worked in the past, but at the moment, with banks under pressure, building and pest inspectors under pressure, we're not really sure if they're going to end up being further restricted. I tend to think if you can allow some breathing room by extending those dates, whether you can push that 14 days to 21 or 28 or 35 and push the settlement period to 35 or 42 or 49, I tend to think that would be a sensible idea, but we'll talk about a few other ways of dealing with timing issues shortly. Question 1. What if there's a delay in receiving a search result or information to satisfy finance or building and pest? If there's a delay that makes it difficult to meet some of these deadlines, there's no unilateral, one-sided right for a party to extend these dates. It's going to have to be done by way of mutual agreement because unfortunately in the REIQ contract there's nothing that would cover COVID-19 in relation to deadlines for particular conditions to be satisfied. It's a little bit different with regard to certain actions which may need to take place for settlement, which we'll talk about shortly. Rather than relying on mutual agreement, you might also look to include special conditions in the contract, either ones that have been pre-drafted by a solicitor provided by the REIQ, which are drafted by solicitors, or to approach the solicitor acting for your seller or acting for the buyer to draft a special condition which suits their client. Question 2. What if the current sellers or their tenants are currently quarantined in a property and can't leave the house in order to provide vacant possession for settlement? The legal rights in this situation are going to vary depending on what's in the contract, both the standard terms and any special conditions. Under the standard terms of the REIQ contract, there are provisions which allow for a suspension of time in relation to a delay event. Within the definition of a delay event, there is no specific event which would cover COVID-19 or the coronavirus or infectious diseases. The closest we have is an act of nature. This wording appears in the context of other types of natural disasters like tsunamis, floods, fires, things like that. However, there's certainly an argument that an act of nature might include any natural event like the spreading of a virus. Alternatively, a delay event also includes a lawful order or direction from government. If a seller or tenant must isolate rather than just choosing to isolate, this may well trigger the operation of the suspension of time under the REIQ contract. So if a seller or tenant must isolate rather than just choosing to isolate based on the medical recommendations and government advice, it's likely that you may be able to argue that a delay event has occurred and therefore the suspension of time provisions will operate under the REIQ contract. However, it's a really critical ingredient that the delay event is the sole cause of the delay. For example, if a seller is quarantined in their home and can't provide vacant possession, but at the same time they have a mortgage and they have not yet organised their release of mortgage, and so the reason that they cannot settle is both the inability to release their mortgage and the inability to provide vacant possession, the seller is not going to be able to rely on the suspension of time clause in that instance. In that situation, the seller will not be ready, willing and able to settle, and a buyer aware of this will potentially be able to terminate the contract and of course pursue usual remedies under law. Question 3. Is there a standard special condition I can put in contracts, or should I be getting special conditions to put in contracts? The Queensland Law Society has put out guidance to say that there will be no standard special condition that will be offered or recommended in the case of COVID-19. There's no one-size-fits-all approach. Each contract and property and set of parties is different, and what they may need is different. I'm not aware as to whether the REIQ has any plans to offer any suggested COVID-19 special conditions, but what I'd recommend is that in each case you run it past the relevant solicitor that's acting for the party that needs the condition, whether that's the buyer or the seller or both, and run it past their solicitor. I'll share with you a couple of thoughts I have around special conditions, but as I say, it varies from case to case. One special condition that you might consider putting in is just a special condition to help clarify whether the suspension of time will operate in the case of a COVID-19 related delay. So what this involves is varying the definition of a delay event to say that a delay event includes not only acts of nature and floods, fires, etc., but also that it specifically includes an infectious disease, an epidemic, a pandemic, perhaps that it specifically includes the coronavirus-related delays. Another variation might be to give each of the parties the ability to extend for a particular time period for no apparent reason. This might just give some flexibility if either of them hits a hurdle due to COVID-19 that gives them some breathing space. That might be the ability to extend settlement by 28 days or to extend settlement for 60 days. It really just depends what the parties are comfortable with, but it at least gives the parties a mechanism to push out that date without having to reach mutual agreement. Another concept I've worked with recently is just amending the definition of business days and then having the key dates all be based on business days. So instead of 28 normal days, you might have 20 business days. By hinging everything on business days, you might then use special conditions to redefine what a business day is and to specify that a business day does not include a day where, for example, banks are closed that the parties are relying on, where building inspectors are closed, where valuations cannot take place. Naturally, such a clause would require a fair bit of specific wording and some careful thought, but that's just another idea. And lastly, the fallback is always to negotiate between the parties to mutually agree on an extension. And obviously, the more creative people can be, the better at these times, and also the more collegiate. We've had a lot of discussion coming from the Law Society about being collegiate between members of our profession. And so I think as well, if we can embrace a level of collegiality between agents, bankers, solicitors, and the parties, most contracts can probably be extended to allow settlement to happen. Of course, as a solicitor, our duty to act in the client's interests prevails over any notion of doing what's best for the economy. But of course, in an indirect sense, I hope that as many contracts as possible can stay on foot so that the economy doesn't take too big of a hit in this time where it is going to be challenging, it is going to be tough. Thank you everyone who's taken the time to listen to this. I know there's a bunch of others putting out great content at the moment. The REIQ is putting out a bunch of content. I see Tom Panos is putting out a lot of content, and there's many others out there. So well done to everyone who's doing that, and all the best, guys. Cheers. Fox out.